Good morning, everybody, and welcome to our post-Brexit immigration rules webinar, which is hugely relevant given the implementation of these rules earlier this month, the Brexit discussions that are ongoing. My name is Barry Stanton, and I'm one of the partners in the Employment and Immigration Group, and I'm also speaking with Claire Taylor-Evans, who is a Senior Associate Solicitor and a Specialist in Employment and Immigration Law. Hello, Claire.
Hi.
Before we get going on the webinar, there is a chat panel at the bottom of the screen for anybody who wishes to ask a question, to raise a question. You'll have heard Kerry Williams, who works in our marketing team, speaking at the beginning to get us going. Kerry is going to be monitoring the questions coming in, and we'll be asking questions at the end to both Claire and I. So we look forward to receiving as many questions as possible. If we're not able to answer your questions live on air today, what we will do is we will produce an FAQ sheet, which we will send out during the early part of next week. So let's have a look at our agenda today. So the agenda today is we're going to start talking about EU nationals already in the UK and what they need to consider doing. We're then going to look at the new regime for people coming into the UK from 1st January 2021. We'll look also at other routes that are maybe available to individuals who want to come to the UK, so outside of the skilled worker route. And then looking at what employers can do now. So there's a lot to get through. Hopefully we can manage to do that inside the hour. It may be a little rushed, but we hope you enjoy what we're going to talk about. So what happens to EU nationals already in the UK? Well, Irish citizens are able to continue to live and work in the UK as they do now, not because of their status within the EU, but because of they live within the common travel area. So their rights arise outside of our relationship with the European Union. For European Union, EEA and Swiss nationals who are already living in the UK on 31st December, they will continue to be able to live and work in the UK without the need for a visa, provided they apply for settled status under the EU settlement scheme by 30th June 2021. Many have already done so, but there are still many more who will need to do so. And as Claire and I were discussing a little earlier, there's no benefit to anybody in waiting. It may be that you get to the 5 years, and we'll talk about it in a moment, but there's no need for them to wait. So what is EU settled status? Well, EU settled status is for those, as I've said, who are already in the UK on 31st December 2021. And those who apply for settled status will either be given EU settled status or pre-settled status. Both statuses give the right to live and work in the UK after 30th June 2021, but those who are given pre-settled status will have to apply later for settled status when they reach the 5-year threshold. So as you can see, individuals must apply by 30th June 2021, and if they can demonstrate they have lived in the UK continuously for 5 years, they will be given EU settled status, and if they can't demonstrate that, they'll be given pre-settled status. And what they have to do is they have to demonstrate they've lived in the UK for a continuous period of 6 months in any 12-month period. And the application is fairly straightforward. They'll need to provide some photo ID and proof of residence. And proof of residence can be provided simply by giving their national insurance number, and that can be checked. And if that gives the relevant information to the Home Office, that will be sufficient. Other than that, there may be documents they need to produce which will demonstrate that they've lived in the UK for the requisite period of time. And some documents will cover a period of time, and some documents will only cover a month. So an annual bank statement would cover that 12-month period, but a monthly bank statement would only cover that period of 1 month. The benefits to having settled status, well, individuals can continue to use the NHS free of charge. There's no need to apply for a visa to work. And also, when individuals have settled status, they can leave the UK for up to 5 years without losing their settled status. And as I said, because they don't need to apply for a visa, they'll be quite interesting to employers who won't need then to have a sponsor license to employ them. Right to work checks. Employers currently are required to carry out right to work checks before individuals start working for them. And this obligation will continue unchanged up to 30th June 2021. EU, EEA and Swiss nationals can continue in that period to produce their passport or ID card, or they can have an online right, there's an online right to work checking service. One of the issues we don't know yet is what happens after 30th June 2021. And the tricky area is that if somebody arrives after 31st December, it may not be clear from their passport whether they were in the UK before or after 31st December 2021, so whether they need a visa or not. So there are some difficult issues there to be sorted out. And for other people coming to the UK, we'll need to produce a document from what's called List A, which will demonstrate that they have a continuous right to be in the UK. So a visa giving them with indefinite leave to remain, or a List B document, which will show that they have a limited right to remain in the UK. And that document would then need to be checked as you come to the end of that period. Ooh, gone the wrong way, sorry. So now Claire's going to talk about what's coming in with the new regime. Claire. Oh, sorry, that's me, isn't it? So we're going to talk about skilled workers, the skilled worker license. So this replaces the tier 2. And as you can see, a skilled worker license is a commercially valuable asset provided at high regulatory cost, and a sponsor must earn and retain the UKVI's trust. So it's a really important status to have. If you're granted a license, it's about trust. It's about the Home Office trusting you to comply with your duties. And those duties are quite extensive. There's extensive record keeping duties. So for example, you need to keep a copy of all the sponsored migrants' passport pages, keep a copy of their contract, make sure you have their up-to-date address, telephone number, and mobile telephone number. And as Claire's going to talk about, and some of you will be aware, the resident labour market test has gone, but there's going to be a need to demonstrate that you've recruited this person properly and not just created a job for them. So you're going to need to keep names and total numbers of applicants shortlisted for final interview, details of the final interview, reasons why others weren't recruited if you're recruiting an EU national or a foreign national. There are reporting duties. So you need to report if people are promoted or if there's a change in their job. You may even need to consider whether if they've been granted a sponsor license, a certificate of sponsorship, whether you need to get a new certificate because their duties have changed significantly, whether they've gone on maternity leave or paternity leave and are not working, change in salary levels other than an annual salary increase. And also the UKVI can come and audit your processes to make sure you're doing what you've said you're going to do. And if they find that you're not, then they can revoke the license. And revoking the license has quite serious implications because it will mean that you're no longer able to employ those people who need to have a visa. And there's also a cost to having these having a sponsor license. So you need to pay a fee of £1,476. So in determining whether they're going to grant a sponsor license to an employer, the UKVI will need to consider a number of issues. But before you get to that stage, employers need to consider what sort of license they're going to apply for. Are they going to apply for just a general license, or are they going to apply for a single company, or if they're a group of companies, do they apply for a license covering all of their companies or some of the companies? And there are issues there to consider, because if you have a problem with your license and you've covered all of your group companies within one license, well, the whole group will lose their license. Whereas if you split the licenses between a number of operating companies, you may have 3 licenses for the group, which is a little bit more complex. But the fact that one company has a problem and loses its license doesn't necessarily mean that you will lose the license for all the other groups. And then you need to consider if you're a company that has foreign offices, whether you need to have an intra-company transfer license. So there's a lot to consider around what sort of license you get. But equally, you need to satisfy the Home Office that you are eligible. And as you can see, you must have no unspent criminal convictions, no history of failing to carry out sponsor duties, and you must have appropriate systems in place to monitor sponsored workers. And that means you have to be able to check they have the skills and qualifications needed for the job, that you'll only assign a certificate of sponsorship when the job is suitable, and that you will inform UKVI if the migrant is not complying with a condition of their license. And suitability. So suitability means you need to have adequate systems in place. The Home Office can attend unannounced at any time to make sure that you're carrying out your duties. And you need to demonstrate that you can offer genuine vacancies at the required skill level. And Claire will talk a little more about the required skill level and the changes that have been there. And the license is granted for a period of 4 years. Now, there's a very important point to note here. So many of you may already have a sponsor license, and sponsor licenses will roll over into the skilled worker license. So if you had your sponsor license granted on the 1st of January 2018, it's now 2 years old. The skilled worker license will run for another 2 years before it expires. So you don't lose anything. And you don't have to do anything. It just automatically happens, which is really important. And then appointments. Who's going to fulfill the roles? Well, there are a number of key personnel. So the first and most important person is the authorising officer. And the authorising officer should, in practice, be a senior paid member of staff or office holder who has sufficient authority to amend HR policies and procedures. And they are responsible for deciding who should fulfil which roles and how many users of the sponsor management system there should be. Now, there must always be an authorising officer. And if the authorising officer leaves without being replaced, then the sponsor licence will be revoked by the Home Office. So it's worth ensuring that whoever is going to be appointed as the authorising officer, there's a big flag on their personnel file that if they resign to go somewhere else, that comes up as a key thing for you to do. Because Claire and I have seen on many occasions, there have been issues around authorising officers leaving businesses and having to hurry very quickly to put somebody in place. Now, the key contact is the link with the Home Office. It can be the same person as the authorising officer, but it could be somebody different. But again, it needs to be somebody senior within the organisation. And then the level 1 user. Well, the level 1 user, again, could be the authorising officer or it could be somebody else. And they have access to the sponsor management system. And they must also be an employee or director or a UK-based representative. And the level 1 user accesses the system and carries out the day-to-day duties. And when you apply for your license, you only need to specify one level user. And once they've been appointed, they can appoint other level 1 users. And there must always be a level 1 user in place. If you don't have a level 1 user, then the sponsor license can be revoked again. And their obligations, well, they can do things like assign the certificate of sponsorship to the worker, ask for an increase in the number of certificates of sponsorship you can assign, tell the Home Office about minor changes in detail or changes in the circumstances. And so one thing they may have to notify the Home Office about is if you acquire another business through a cheapy transfer, you have to notify them of that within a certain period of time. So there's lots for the users of the system to do. And a level 2 user is somebody who can also access the system but has fewer responsibilities than a level 1 user. So, Claire.
Thanks, Barry. So as Barry said, from the 1st of January 2021, there will be a new immigration regime, and it will apply importantly to EU workers as well as those coming to the UK from the rest of the world. And many of you will already be familiar with the Tier 2 regime, and it is based on this. So the Tier 2 regime is currently in place for UK employers looking to bring people into the UK from outside the European Union. So it's based on the Tier 2 regime, but there are some very important tweaks, which is welcome news for employers. The first of those is the removal of the resident labour market test. Now, many of you will be aware of this. It is essentially a recruitment test to ensure that the employer is not undercutting the domestic labour market. And it generally involves the employer having to advertise for 28 days. There's some very strict criteria on where the advertisement is placed, what is included in the advertisement, and the employer has to show that there is not any resident worker who is suitable for that role before they can offer that role to the migrant worker. So it was very difficult for employers to do this, and that is now being removed or has been removed under the new system. The other welcome relaxation of the rules is the strict salary thresholds. So under the old system, you couldn't bring somebody into the UK generally unless you paid them £30,000. Under the new system, this has been reduced to £25,600. And also the skill level has been reduced. So again, you couldn't bring somebody into the UK under the old system unless you were filling a role which was at degree level, so RQF level 6. Going forward under the new system, that has been reduced down to RQF level 3, which is A level. And finally, under the old system, there was a cap on the number of visas that an employer could get, known as restricted costs. And the employer had to apply every month, and the application was scored in terms of priority, but there was a limit of 20,700 annually. This has been removed under the new system. So the idea is that the system should be quicker and more streamlined and easier for employers to meet that criteria. Now, is that the reality? Let's have a look. If you could go to the next slide, please, Barry. Thank you. So the new system is points-based, and that involves the employer and the migrant having to score 70 points. And as you can see there from this rather whizzy table that I have produced, there are mandatory categories under which the employer and the migrant has to score points, and also tradable points. So looking there at the column on the left, the first of those categories is there a licensed sponsor? So if the employer has done everything that Barry has said, so applied for a skilled worker license, then they will automatically get these 20 points. The next category is the employer offering a skilled job? So I've already said that the skilled job level has been reduced now to RQF level 3. So when an employer is going through the process, how do they know that the job they're planning to offer is at RQF level 3 or above? Well, helpfully, the government has produced a list of every single job known to man in the UK, which has obviously been a jolly job for some civil servants, and they have graded every single job to say whether or not it's RQF level 3 and above or not. And they've also put into this list what they consider is the going rate for the salary to be paid for that job. And that's important later on. I'll come on to the other side of the table. So if you look at that list and say, okay, I know I'm offering a job at RQF level 3 because it says there on the list, then you know you will score another 20 points. And then the final mandatory category is English language. So this is a test for the migrant worker. Do they meet the required level of English language? Now, if they have studied in a UK university, they will automatically be granted these points. If they come from a majority English-speaking country, they will be granted these points. So that would be Australia, America, etc., not South Africa. And if they don't fall into either of those categories, then they will need to undertake an English language test, and they can do those in various test centres in their countries. Then on the right, there's this concept under the new regime of tradable points. So you can see there in the third box down, generally, if you have scored your mandatory 50 points from the first category and you need to get to 70, you would ordinarily need just to pay a salary of £25,600 or above, and you would score your 20 points. However, what the new system does, it allows you to pay the migrant less than £25,600 if any of the other special categories are met. So you can see there is a job in shortage occupation is a special category, a PhD in a relevant subject to the role, a PhD in a STEM subject, and if the applicant is a new entrant. So I'll come on to this now on the next slide. So what is a new entrant? Well, generally this is someone in the early stages of their career. Normally somebody who is young, so under the age of 26, you would qualify as a new entrant. And there are also certain other categories. So for example, if the individual is undertaking postdoctoral roles in science or higher education, and also certain students switching from tier 4 visas. So there are certain other categories, but generally, if an individual is under 26, they can score special points in this new entrant category, which would allow the employer to pay less than the £25,600. Another example is if the role appears on the shortage occupation list. So this is, again, a list that the government has produced where there is a labour shortage in the UK and is acknowledged. And you can see there from the slide that there are a number of categories on the shortage occupation list, which may be of particular interest to our tech clients. So web design, IT business analysts, etc., architects, chemical scientists, and mechanical engineers. And if the role appears on the shortage occupation list, then, as I say, the employer can actually pay the worker less, provided it is always above the very minimum salary level of £20,480. Next slide, please, Barry. So let's look at this in context. An example. Fernando is Spanish. He has a job offer as a lab technician. The salary is £21,000. He speaks English fluently, having studied in the US. He has a science PhD. So looking at our table, yes, he's got a job offer from a licensed sponsor, tick, that's 20 points. The skill level is the requisite level because we know a lab technician qualifies RQF level 3 and above, another 20 points. Fernando has obviously satisfied the English language test in some way. It's not clear from the slide. And then we have here then the salary level. So salary of 20,480 to 23,039 and 99 pence. Well, that doesn't meet our minimum criteria of 25,600. So ordinarily, Fernando wouldn't qualify. But fortunately, Fernando has a PhD in a STEM subject relevant to the job, so he can actually qualify with the 20 points in that special category, enabling him to come to the UK. Next slide, please. Ricardo has a job offer to be a mechanical engineer at 26,750. He meets the mandatory criteria of 50 points. The salary is above the general salary threshold, but below the going rate of £33,400. So this going rate, as I described earlier, is what the government feel that role should be paid at in the UK. So the going rate for a mechanical engineer is obviously £33,400. So what we're saying here now is salary is 80% of the, more than 80% of the going rate, 26,720. And the mechanical engineering is, however, in a shortage occupation, in the shortage occupation list. So what that means, of course, is that Ricardo ordinarily wouldn't have met the points criteria, but because he falls, or his role falls into this special category in the shortage occupation list, then he would be able to come to the UK. Next slide, please. I just want to touch on intra-company transfers because I think this is of significance for a number of our clients. So if you are a UK employer with a linked entity overseas through common ownership and control, the intra-company transfer route will enable you to bring existing workers to the UK. And many of you will be familiar with this route from the old system, the Tier 2 system. Not much has changed in this respect, and the changes that have happened are actually very welcome changes. So this is for roles that are at RQF level 6, so degree level roles, and the role in the UK has to be paid at £41,500 at least, or the going rate as specified in the codes of practice if higher. And the existing worker needs to have been employed in the overseas company for at least 12 months, unless they're coming into a job that is highly paid, which is currently £73,900. One of the one of the pieces of welcome news for an employer in respect of the ICT category is the removal of the cooling off requirement. So many of you will be familiar with this, that if somebody was working over here on an intercompany transfer visa, they would have to go back to their country at the end and wait a period of 12 months before coming back to the UK, and that has been removed. So that's very good. But also there's the ability to switch in country from Tier 2 ICT into Tier 2 General, which is particularly good news for the migrant workers, because of course the intra-company transfer route doesn't lead to settlement, whereas Tier 2 General or the skilled worker route would allow the migrant to settle here. So that is good news. Next slide. So what about the costs? Well, many of you will be aware of the skilled worker license costs because you're already license holders, and Barry's talked as well earlier in our presentation of that, about that. But there's also additional costs. So on top of your license, you've got your visa costs. So depending on the length of the visa and the type of the visa, you can see there from the slide the different categories. In addition to that, there is a fee for assigning the costs of £199, and the migrant will also have to pay the immigration health surcharge of £624 per year, and that's payable upfront for the length of the visa. And of course, there is the immigration skills charge, which is essentially a tax on businesses looking to recruit labour from abroad, which is £1,000 per year of visa, again payable up front. So if you're looking at a 5-year visa, then you're looking at £5,000 cost on top. Next slide, please. Over to you, Barry.
So back to me. So I thought it'd be interesting just to look at a few other routes into the UK for businesses, particularly in the Thames Valley. So one of these routes is the Global Talent Route, which was launched in February 2020. And the aim of the Global Talent Visa is to attract the very best and brightest talent from around the world. The route reformed and replaced Tier 1 exceptional talent, and is designed to attract recognized global leaders and the leaders of tomorrow in science and humanities, engineering and the arts, and digital technology. Top scientists and researchers are able to benefit from a quicker endorsement process as part of the fast-track STEM scheme. There's also plans by the government to set up a cross-departmental unit called the Office of Talent, which will make it easier for leading scientists, research and innovators to come and live in the UK. Now, in order to be able to come through the Global Talent Visa, applicants must be endorsed by a recognised UK body, which has been approved by the Home Office. And individuals can apply to one of the following endorsing bodies who will verify their expertise before they apply for the visa. So that's the Royal Society for Science and Medicine, the Royal Academy of Engineering, the British Academy, UK Research and Innovation, Tech Nation, and the Arts Council for England. Once endorsed, subject to criminality and immigration checks, migrants are then given a highly flexible permission to come to the UK, where they can be employed or self-employed, and they can work, they can change jobs without informing the Home Office, they can travel abroad and return to the UK for research purposes and bring their dependents with them. And there is no limit on the number of eligible individuals who can use the route. And then the fast-track STEM scheme. In order for someone to qualify under this, they must be in receipt of a named award or fellowship and in a senior academic position and part of a publicly funded research team in receipt of prestigious funding or awards. So again, it's really for very senior and specialist scientists. And then the startup and innovator routes. Well, the startup and innovator routes are designed to attract entrepreneurial talent and innovative, scalable businesses to the UK. The startup is for those starting an innovative business for the first time, and the innovator route is for those with industry experience and at least £50,000 of funding. And again, each applicant must have the support of an approved endorsing body, and that will either be a higher education provider or business organisations with a track record of supporting UK-based entrepreneurs and also having the support of a government department. Again, business visitors are people that have been coming to the UK and have under the old system and the new system, but I thought it was worth focusing on that for a moment. Now, some business visitors may or may not need a visa to come to the UK, and that just depends on their nationality. But business visitors will need to satisfy the genuine visitor requirement. So, the fact they'll come to the UK to visit and then leave. But the problem for business visitors is they can't work save within permitted activities. Now, certain activities are permitted, and you can see on the slide what they are. You can attend meetings and conferences and seminars. give a short series of talks, provided they're not commercial events, negotiate and sign contracts, attend trade fairs, provided there's no direct selling going on, carry out site visits and inspections, and gather information for their employment overseas. So it's a very limited scope of what can be done for a business visitor. It's really coming in and going out. Now, for a business visitor who comes from a parent company to a subsidiary, well, they can come into the UK for the purposes of advising and consulting their subsidiary or parent company, troubleshooting, providing training, sharing skills and knowledge, and all of this is for a specific internal project, provided no work is being carried out directly with clients. Internal auditors may come into the UK to carry out a regulatory or financial audit. And employees of foreign manufacturers may install, service and repair equipment or computer hardware or software where the manufacturer has a contract with the UK company. So business visitors is a very limited scope for people to come in. It doesn't give people the opportunity to do very much. So if people do need to come in to visit and do things, you need to be very clear about what they are doing. It may be necessary to apply for some other form of visa if what they're going to do steps outside what's permitted for business visitors. And I also wanted to mention graduates. The government are going to launch a new scheme in summer 2021, and the aim is to retain those students who studied in the UK, and they'll be allowed to remain in the UK for 2 years where they've got a bachelor's degree, or 3 years if they've completed a PhD, and they'll be able to work at any level and switch into other routes. And importantly here, there's no maintenance requirement or no language requirement, because if they've studied in the UK, they'll be deemed to have the English language requirement in any event. So that's how graduates can stay and work in the UK. And we'll have to see how that scheme develops as it's launched later next year. So passing back to Claire.
Thanks, Barry. So what should businesses be doing now? Well, hopefully you're already well ahead on the first step. So auditing your workforce, finding out whether you've got any risks or vulnerabilities. Do you have a high reliance on EU workers? Because obviously from the 1st of January 2021, it's going to be much harder for you to recruit EU workers who haven't already got a settled or pre-settled status. So make sure that you're fully aware of how your workforce is made up, and make sure that any existing staff are aware of the EU settlement scheme, how to apply. As Barry said, it's relatively straightforward. They should be encouraged to apply, but obviously as they don't have to apply until June next year, you can't force them to do so. But they certainly should be encouraged and given sufficient information on this. Plan where you're going to recruit from after the 31st of December 2020. If you feel that any of the roles that you will need to fill post-January will meet the criteria as set out under the new immigration scheme, so are they going to satisfy the skill and the salary level, or do they fall within the shortage occupation list? Then consider whether you need a skilled worker license. As Barry has said already, if you already are have a sponsor license, that will automatically be converted to a skilled worker license. But if you haven't already got one of these, I would recommend that you start thinking about that as soon as possible. I have been helping a number of clients in the last month who haven't got one, and contrary to what the government say about it being a straightforward application, it really isn't. It's complex. There's a lot of original documentation that needs to be provided. You need to ensure that you're audit ready, that you have robust HR practices and systems in place, that you can appoint the key personnel that Barry's already talked about. So there's a lot of planning and preparation that goes into this, and it really isn't a straightforward exercise. After you've submitted your application as well, you're looking at an 8-week turnaround process. So if you want to be ready to recruit in January, you really are up against it. So I would say start thinking about that now. And obviously, making sure that the business is aware of the changes. I think that's really important, managing the business's expectation. I've lost count of the amount of times I've had a call from an HR director saying, we need to get this person into the UK ASAP because the MD has promised him a role. And I think if the business can understand the complexity and the length of time it takes, and obviously that's a very important part of your role. So I would also say that providing Brexit training and right to work training to your staff is key. And if you do need any help with skilled worker licence applications, obviously we can help you with that, but also more importantly, understanding what comes with that. So as Barry said, trust is incredibly important to the Home Office. They take this very seriously, and it is absolutely fundamental that you understand your sponsor licence duties to ensure that you can protect this commercially valuable asset. So do invest in compliance training.
I think that's very important, Claire, because if people don't understand the obligations in the license and how important it is, it's very easy for it to be lost. And I was talking to someone not that long ago who had been with the Border Force and joined someone at the point they were in difficulties with their license, and the fact they knew the person coming in made a huge difference to the discussions they were having and allowed them to keep their license. Otherwise, that business was in real difficulties. So that takes us straight on to questions. Kerry, do we have any questions?
Yes, one moment. Let me just get these up. Okay, so apologies. So we've got one here. Do we need to gain evidence from a current employee that they have gained pre or settled status as post 30th of June 2021? They will require this to continue to be able to work, question mark.
I think, and I've had this question asked of me a lot lately. As Barry alluded to earlier, the only obligation for an employer from the 1st of January next year until the 30th of June is to carry on doing the right to work checks as normal. But obviously that is problematic for employers because people arriving from the 1st of January next year may well need the right to work in the UK. And how do you distinguish those who qualify for settled and pre-settled status and simply haven't applied yet, or people who actually do need the right to work in the UK or need a permission to work in the UK? All I can say really in respect of that is the government have said, if you carry out the right to work checks in the normal way, you will have the statutory excuse. So it subsequently transpires that that worker is here illegally, then you have a statutory excuse and a defence against a civil penalty. Now that doesn't really help if you are aware the person needs a right or permission to work in the UK. So if it's obvious to you, then potentially there is a criminal liability there of knowingly employing an illegal worker. But you've got to balance that against the risk of discrimination. So if you're saying to your staff, well, you must do this, or you must show me that you've got settled or pre-settled status, the UKVI are very clear that that could be a discriminatory act. So I think in that situation, you've just got to use common sense. I mean, people come into the UK for the first time, you'll have their CV. You can ask them at an appropriate stage in the recruitment process if they need permission to work in the UK. And as Barry said earlier, what we will need to do post the 30th of June next year, we're still waiting to hear from the government. So we hope we will get further guidance on that.
Thank you, Claire, that was very helpful. We've got another question here. Can we insist that our employees apply under the EU settlement scheme and ask to seek evidence?
I think that sort of really follows on from Claire's question. You can't insist that your employees make an application under the EU settlement scheme. You can tell them about the scheme. You can I think you can encourage them and say, look, the scheme is here. So you can advertise it on the government's behalf and make them aware of it. But the government the Home Office have been very clear, you cannot ask them to see evidence that they have applied or they have been granted EU settled status prior to 30th June next year. As Claire said, and as the government say, if you do that, then you're potentially discriminating against your employees by actually asking the question.
Brilliant. We've got a question here from Sophie Lee. For the 1,000 cost per year, can we sponsor someone for a number of years and then extend?
The 1,000 cost per year, I think Sophie's referring to the immigration skills charge. So that would be for the duration of the visa. So if you had a 5-year visa, you'd have to pay £5,000 up front. If the migrant was to leave before the end of the 5-year period, you can get a refund from the Home Office. But generally, if you were to extend the visa, yes, you would have to pay.
Okay. And we've got an hour, haven't we? So we've got time for a few more questions. Previously, there was a requirement, this is from Rob Brown. Previously, there was a requirement to raise the salary of an existing sponsored employee to meet the experience rate when renewing a visa once they reach the age of 27. Is this still a requirement, or does the new point system apply as for new entrants?
So in the new entrant category, you can only use that for 4 years. So if you were planning to bring somebody over on a visa for a longer period of time, which is similar to the old system, if you were planning to issue a 5-year visa, then the new entrant rate wouldn't apply essentially. So it's going to be similar under the new system.
Brilliant. Would you recommend paying a lawyer to help you with the application for a skilled worker licence to ensure full compliance, or are all info online and support is offered?
I think obviously we'd say yes, but more seriously, I think as Claire was saying, it is a complicated process. The Home Office say it's very straightforward. I'm not sure that it is. You find information in different places. It could be really straightforward, but finding the documentation, getting it in the right order, getting it trying to think of the word, witnessed and signed to say it's a proper copy, making sure you give them, the Home Office, all the information they need and want, is a bit of an effort. And if you make the application and it is rejected because you don't have the relevant work, and if you make the application and don't have all the documentation, that you get about 3 days to get the information to them. And if you miss that, they'll just send it back to you. And the problem with it being sent back to you is that it's been withdrawn by the Home Office and you can't then apply for 6 months. So it's really important to make sure you get it right first time. And the other thing about if you get someone to help you who knows about this, they can then help you with training the staff, making sure that you're audit ready, so that your systems do comply with what the Home Office wants. So it's not just about physically putting the papers in, it's about making sure everybody understands their obligations and what they have to do for the application, but also then going forward and using the sponsor management system. I think that's the really important part.
Yeah, I think I would add, I mean, you can obviously go onto the government website and look at it and do it yourself, but I've had a number of clients who've started to take that route and then said, actually, it's not at all clear. Can you have a look at this for me? And then said, oh, thank goodness, we've come to you because we couldn't have done it otherwise. So yeah, I entirely agree with Barry there. It is much more complicated. Getting the documentation is much more complicated. And we offer a review service. So we will look at all the documentation and scrutinise it and make sure that your application has the best chance of success. And as Barry says, that everybody is aware of the importance of their responsibilities and duties going forward and the importance of this licence.
Brilliant, thank you, that was really helpful. Is the salary level linked to a specific amount of hours per week?
So the going rate is linked to 39 hours a week. But if somebody is working more than that, then the going rate for that job will go up. If they work less hours than that, then the going rate goes down. But the threshold levels that Claire talked about, so the 20,480 and the 25,600, those levels don't change. So those are the levels at which the various points are awarded. So you can't have somebody earning less than £20,480 and then sponsor them, because that takes you outside of the system.
Brilliant, thank you. And are regional differences in salaries taken into account?
Again, no. There's a survey that's carried out on about 1% of employee salaries across the country, and that's the salaries that are fixed, and they're fixed across the country. So if you're in the southeast, it's perhaps easier to pay somebody at the going rate, whereas if you're in maybe the northeast or northwest, where salaries are potentially lower, it may be more difficult to get to that salary level.
Yeah, and that's a real problem. We've got a number of clients, or I have a number of clients in Wales where the going rate is lower for the jobs. And this was something that was raised with the Migration Advisory Committee, which advises the government on all immigration matters. It was raised during the consultation in respect of the new immigration system, but unfortunately it wasn't implemented.
We've got another question here from Constance. We're a registered charity with 96 employees. Are we entitled to the reduced immigration skills charge? No.
Yes, I think you probably would be.
Okay, and we'll just have one more then. Hi there, from anonymous. If we were to say we wanted to sponsor an employee from Italy on a T2 ICT route, would they need a UK contract as well next to their Italian contract?
Yes.
Okay. Okay, I think, yeah, that looks like that's the end of the questions there. So I'll pass back over to you.
Okay, well, thank you very much. Thank you everyone for your questions. If there are any more questions, do please keep them coming in, because we will monitor the box and we will try and answer all of those questions. And we've got a few others that we've seen coming around, so from other people when we talk. So we'll put those into the FAQ as well to give you a bit more information. It just leaves for me to provide you with the final slide, which gives you details of how to get in touch with us. Claire, thank you for contributing today. Thank you everyone for listening. If there are any questions, or if you want to get in touch with us, please get in touch with Claire or me. Thank you very much.
Thank you.